Thank you. Next, we will hear remarks from Mr. Adi Heriadi as CMC, Psycholog, as the Vice Dean of the Faculty of Economics and Social. Mr. Adi Heriadi, the time is yours.
Okay, thank you. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. The Honorable Head of the Law Study Program Unjaya, the lecturers, the speakers, Mr. Duan Yanram, Mr. Arista, and Mr. Ajit Sidhu, and the participants who attended today's international webinar, Data Privacy in the Digital Age. Thank you to everyone of you for being here today at this wonderful place. First of all, I would like to thank God Allah Subhanahu wa Ta'ala, who has been giving blessing and mercies so we can attend today in good condition. Talking about data privacy nowadays, it is necessity because of the digital era where everything can spread quickly via the internet. For this reason, today's webinar, which look at how legal protection for personal data in Indonesia, China, and Malaysia is essential and exciting to discuss. Welcome to the webinar. Hopefully, you will gain new knowledge. Bismillahirrahmanirrahim. On behalf of the Faculty of Economics and Social Affairs, Dean Unjaya said, the international webinar for the Unjaya Law Study Program is official open. Thank you very much. Assalamualaikum warahmatullahi wabarakatuh. I will hand it over to our Master of Ceremony.
Thank you very much, Mr. Adi Heriadi, for the remarks. Next, we will proceed to the webinar session, which will be led by Mrs. Gina Salsabila Aten as our moderator. Before I hand over the session, allow me to read the moderator's CV. Mrs. Gina is a lecturer in the law program at Jenderal Ahmad Yani University, Yogyakarta. She completed her bachelor degree at Muhammadiyah University of Yogyakarta and pursued her master's degree specializing in constitutional law at the University of Indonesia. Mrs. Gina Salsabila Aten, we now invite you to read the webinar.
Good morning, speakers and all of the audience. Thank you, Ms. Talia, for a brief introductions for our event today. My name is Gina Salsabila Aten. It gives me a great pleasure to be the moderator for the international webinar under the topic Data Privacy in the Digital Age. Before the presentations begins, let me tell you how this webinar will run. Each speaker will present the material for about 30 minutes. After that, there will be a questions and answer sessions for approximately 30 minutes also. And finally, the sessions will be ended by a conclusions. Ladies and gentlemen, now we begin by welcoming our first speaker, Mr. Ajit Sidhu. Mr. Ajit today will talk about the data privacy based on Malaysian approach. But before it, I'd like to read the curriculum vitae of Mr. Ajit first. Mr. Ajit is a data privacy enthusiast from Malaysia, and he was graduated from University of London in United Kingdom. Right now, he is pursuing his master degree in University of Malaya. Mr. Ajit is the president and founder of the ATC Law Gazette Society, with the goals to bring people the articles relating law and law debates. He also has a license on General Data Protection Regulations or GDPR certifications by University of Derby in United Kingdom. Ladies and gentlemen, without any further ado, now allow me to welcome Mr. Ajit Sidhu to present his material for about 30 minutes. Mr. Ajit, time and Zoom are yours.
Good morning. May I ask you to help me enable the video so I can share screen? Hello?
Ajit, your voice is too low.
How about now?
Okay.
Okay,
Now,
great.
okay.
Do you mind enabling the video? And may I ask, could you see the screen? Can you see my slides?
Yes, yes.
Great, excellent. Okay. Good morning, selamat pagi. I would be giving a lecture on data privacy with the emphasis and focus on Malaysia, looking in the context of Malaysia. Okay, so now I shall begin the lecture. One moment, yeah. Okay, great. I would like to introduce the PDPA module. I mean, I read it as a module or module on the basis that I would be giving a lecture, but however, I should use the same slides as the materials are the same. I would like to talk about the PDPA in Malaysia, especially in looking at the and focusing on the key subsections that are applicable in the context of data privacy, and also with the amendments that has been passed to show how it impacts data privacy in Malaysia, in the context of Malaysia and the management of data privacy itself. In which an emphasis on the operationalization of data privacy principles to ensure that people do their duties to enforce the act and protect people's data. One moment, my slides are... Okay, from 1 to 7, these are the key principles that can be found in the Malaysian PDPA. These includes the general principle, notice and choice, disclosure, security, retention, data integrity, and access principles. All of these will be discussed by looking at the subsections as well. You may keep a PDPA book or PDF beside you, but however, I shall explain to you as we go forward. Are you ready? Okay. The most key important principle that applies in data privacy in Malaysia is the general principle. One moment, yeah. Sorry, the slides. General principle. Okay, this is just a generic principle that outlines the main rules and the main regulations and the main principles of data privacy. So this includes such as you cannot process the data, a data processor cannot touch the data, they cannot do anything with the data unless the subject, i.e. one of us, has given consent. So you must say, hey, I consent to you that you use my data. This can be usually done by ticking the box and saying, yes, I agree, or so I give your signature. However, later on, I'll show you the exceptions to those who can bypass this consent under section 40, which will be further up. This because the reason for this is it has been done for a lawful purpose. For example, in business context, it would be market research, or some businesses, they sell data. They tell you upfront, we're going to sell data, but let's say you have this e-wallet, we give you for signing up and giving us your data, we give you this particular 10 ringgit or 5 ringgit vouchers. So you're essentially selling your data, but you know about it because you agreed to it. So hence they can process your data and send it across to businesses for market research and other stuff. The data needs to actually mirror the purpose related, which I'll explain a bit further. It has to mirror the purpose. For example, let's say we're talking about market research. Market research, you can collect any data that is relevant to the particular industry. For example, let's say medical facilities or medical stores. What they would need to know is they only would need to know things like your risk, do you have heart problems, all that, and they take the group of people who have heart problems, all that, and process the data. It has to be noted, it has to mirror and cannot be excessive. You cannot take data that is extra and not relevant to the particular purpose, which I'll explain later. Okay. Just a moment, yeah. Okay. This key term here is consent that impacts the data privacy principles in Malaysia and worldwide. Generally, any form of consent is allowed, but the best consent is express consent. Express. You tick the box, you say yes, you give your signature. So consent, when we talked about it earlier, it has to be expressed, the best of the best. I mean, some organizations try to have what do you call not express consent, but this, in my opinion, is unjust. The data subject, the person, the individual needs to be informed this your data is going to be processed, especially if you're looking in the act, the words of the act itself. You need to inform the person what data is going to be collected, what you can do with it, and all that stuff. So when you download a video game, for example, you'll always see there'll be a box saying what they'll do to your data, where the data is being stored, who's the data, the party data, and all that stuff, the cloud. This is actually consent that informing you what needs to be done, but most of us don't read it. We just go down all the way and just tick the box. As long as we can get our game or we can get our thing that we have promised, we tend not to read it. So this is very important. I would recommend for people to actually start reading this. Yeah, okay. These are the section 40 exemptions to the consent itself. One is you're performing a contract, which is a data subject to the party. You're just doing a contract, whatever you agreed to. Number two is with legal compliance. You're doing some legal, your lawyers come and all that stuff. 3 is to protect the interests of data subjects. Number 4 is a hot topic, actually was a case about this Cameron Highlands, if I'm not mistaken. Genting Highlands and the tax audit, Taxes Bureau. So they wanted to take data from the data subjects because for tax purposes, they were keeping the money in Genting Highlands. So in this case, they said, look, you need to get a proper warrant, all that stuff, to get this particular consent. So the threshold before the amendments was still high. But, however, the magistrate needs to give his written signature in order to bypass consent. And the same thing a magistrate is actually. Okay. I would, Arias, may I ask, am I allowed to make this session interactive? Hello?
Yes, sir.
Yeah.
Yeah, okay. I would like to ask you guys, this is a lucky draw, right? This is a lucky draw. Now, what do we do in a lucky draw? What is the purpose of a lucky draw? What is the nature of a lucky draw? Anybody?
Anybody want to answer? It's what is it?
What's the nature?
We want to get fortune based on our lucky, on our luck.
Okay, so it's basically by chance, by luck,
By chance.
or okay. In that particular case, right, by chance and by luck, is this information relevant? My profession, my age, monthly salary, and all this stuff here, is that even relevant? If the main goal is for me to get money by luck, is this part relevant by age? We call it by gender. Okay, fine. I understand address or city, maybe because you want to send a check or you want to deliver the price. But is this relevant? Look at this. Your age, salary, their own cars. Is that even relevant?
Oh, it's not actually. It's not relevant. Too much information.
Yeah. So as earlier as I said earlier, you need to mirror what data you collect according to the purpose. If purpose market research, okay, fine. There's more things you can collect because you're doing it for something. But lucky draw, why would I need this? This is an example of people selling data. They're going to take the data. Once you give a signature, they might sell their data. The worst case scenario, best case scenario, they just keep it inside. They just keep it in their system. But even then, it creates more problems, especially in today's world, where everything's digitalized and we have a lot of cyber attacks. Information can be leaked. Now, the first one, as I mentioned, is a notice and choice principle. One moment here. Okay, notice and choice principle. So this principle just means that you have to give a description. You have to explain to the person what you can do to the data, what you're going to do with the data. So you tell what you're going to do, why you can collect it, sources, rights, and all that stuff. Even things like if you see for Google, if you see where the data is stored and all that, they'll be storing it in. So the last I checked was Arizona, the database. So where they store the data, the cloud, third parties, and all that. So it is essentially me informing what I'm going to do with the data. I'm going to tell him, hey, look, you have a right to change your data, you have a right to delete your data, you have a right to get rid of this and that, and all that stuff. So you're informing the person what you're going to do. This is under Section 7 of the PDPA. Okay, so in the PDPA, there are certain things that cannot be left out. For example, if you inform the third parties who you're going to give the data to, like let's say you're going to put in the cloud. Cloud is actually shared by people. So if you tell them, look, these data can be in the cloud because we cannot store it in our databases. We will put in the cloud, or we will, let's say, give it to somebody to process the data, our subsidiary. You still must tell them. You must tell the what you call right of choice and the limit to process the data. Any obligations. For example, the main obligation to make sure the data that is given is actually accurate. You cannot, you as a data subject cannot give fake data. You must give the actual data. And the result, if you don't supply the personal data, for example, this can include, let's say, you have to give no more RM5 vouchers or no more presents that were promised, whatever that was agreed upon. Because you as a data subject have to give the proper information, but the company has to take care of the data that is being held. Okay, sorry, this is was an error. Yeah. So this is when you can give the data. So when the people can give the data, usually it's when you're asked or when you receive before you receive a particular benefit, like when you play the video game, when you download the video game on your phone, before that, they'll ask you to sign up your data, sign up for this, sign up for that. This is when you as an individual have to give the data. So I shall skip this because time is of essence. Okay, disclosure principle. Disclosure principle under Section 8, what do you call? You have to, it's the same as actually above, it's same as above in form, but you have to disclose this more in depth. It's just more in depth. That's all. Moment, yeah. Okay, more in depth. Okay, I'm going to ask you this. By me putting, let's say this is a educational loan scholarships, for example, I'm giving scholarships to people. By me taking let's say my people who I've chosen, these are the pool of people I've chosen. Am I taking care of their data privacy by putting their names and the IC, something that can identify them in the national newspaper, in public? Because my duty is to take care of the data. You've given me the data. My responsibility is to take care of the data. So I would like to ask you guys, by me putting all the names here, even if even consent was given, am I doing my duty as a data holder or data processor in this context?
It's still violating our privacy.
Yeah, because I mean, I already signed up for these things. Why would you? I already signed up for these things, and the bare minimum is for my data to be kept private. Why are you putting my data in public where everybody can see? I mean, okay, I can understand maybe, let's say it was a lucky draw or something, but still then, right, you didn't have to put the IC number, something that people can use, where the public is something that shouldn't be in public domain. So that's why, as above, it has to mirror the principles that they mirrored the reason that the data was being collected for. Okay, number 3 is the most, actually, I would argue the most important, because some businesses do not comply with it, in my opinion. They don't comply enough with it. This is retention. So we're talking about collecting data for varying purposes as before, but retention principle is a bit interesting because it just means that you have to keep the data for the bare minimum that is required, for your business purposes. So the issue is, The issue is when businesses keep it for too long, when the data processor keeps it for too long. So the data user has to take reasonable steps to also ensure data that is not used, no more data required, is destroyed properly. This can include shredders and all that. Shredders. Some businesses have actually very um, a very advanced method of deleting unused data. So, right, what usually businesses should do is to call in all the sectors, all the what do you call business sectors. For example, your marketing team, call in your accounts team, call in all your other teams, come together and ensure the data that's being retained for is a bare minimum required. It has been the bare minimum for a particular purpose, because the commissioner will change when it's what you call when you can delete the data. But at least as a business, yes, you have to understand they've got goals, they've got things to do. So you come to a middle ground. How long do you need the data for? But in the context of you getting rid of unused data, you can't keep data for 12 years unless you're going to do some market research. But even if you do market research, 12 years seems a bit too long, I would say. So you have to ensure in various of purpose, you call in all the business sectors and come together and say, hey, look, what's the bare minimum we require? Okay. Now, next is under section 12, right? Access to data. That this means the data user has the right to delete all any data. For example, let's say I sign up for this particular e-wallet scheme and I move address, I move house. And one of the key important data is my house, where I stay, where I live, because let's say they'll send me rewards. So me as a data subject, I have to ensure my data that is given is accurate, updated, and all that stuff. Like some people like to put all the wrong addresses, like even when you go to shopping malls, when they ask you to sign up for a free gift, some people will put the fake names, fake numbers, and all that stuff. So, I mean, this is contrary to Section 12, but usually it goes largely unenforced unless there is some sort of mechanism the business can use. What they would do is take away the particular gift, or worst case scenario is the contract gets repudiated or rescinded, worst case scenario. But most of the time, in the context of collecting free gifts from your typical supermarket, most of them do not care, and this largely goes unenforced. Okay, now a security principle. This is a bit important, right? In a sense that not only is it is a principle, but also businesses, I would opine that they do not invest much in it. They don't invest much in AI tools or software and malware to protect the data from being altered, destroyed, or released. So, for example, your typical cyber attacks, this is what they do with the data. They'll take the data and they will either stop the business, do not allow the business to access the data, delete the data, or just leak the data from the organization or something like that. So, a business, what you should do is focus on this principle. But most of the time, what I would suggest is and invest in more tools to protect your data. In addition to the retention principle, get rid of unused data and ensure the data you have is cabal. You cannot go through and take the information and leak it anywhere else. Okay, now with regards to amendments, few months back, right, the amendments to the PDPA were passed. There were amendments passed. I would cover a few of them because I feel a few of them, for example, let's say mandatory breach requirements or even the increased penalties would impact data privacy as a whole in Malaysia. It would impacted by ensuring organizations cannot escape from not discussing it. They will have to discuss it in their board meetings. It's no more in the past where it's relegated to your data privacy team and the CEO doesn't care. Now with the increased penalties, now with the extra duties and all that stuff, the CEOs will be forced to talk about it in the boardroom. They have to talk about it because if not, they themselves will get punished. This is the same logic that Companies Act 2016 uses in Malaysia by the increase of fines to ensure that businesses would in fact discuss this in their board meetings and ensure a top-down approach. From the top, once the instructions are being made, to bottom, everybody complies. Okay, one is the increased penalties, as I've said. The penalties have been increased, financially been increased by a lot. And also now, right, the CEO and all its people, all the top management can be punished now. So they have got no choice anymore. They have got no choice but to ensure all our data privacy principles that we spoke about earlier. They have to discuss it in the board meetings. In the past, it was an afterthought. They didn't care about it. It was mostly about business management and how to run the organization. Now it has changed, it has shifted. They have to care about it. Number two is ensure data processes your businesses comply with the security principle. The threshold has increased exponentially. They have the terms that were used were actually a bit wide, but I would opine is good because it ensures businesses like big businesses, they have to invest in this principle and invest in infrastructure to prevent data being leaked. You have to now invest extra. You have to prevent all of this happening to the data. No more leaks, no more issues and all that. So now businesses, what they have to do, ensure the further development of maybe let's say 2 years or 3 years, increase the protection of the data itself, increase it by systems and mechanisms, maybe encryption can be used and all that stuff. Okay. Next is the mandatory breach notification. In the past, right, it was not really mandatory. Usually, your DPOs and all that would be focused on preventing the data being leaked first. And usually, if it's just a mere incident, usually no. Now you have to ensure with no delay, you go and inform the commissioner. Say, hey, look, there's an issue. We had an issue. Data was leaked or breach has occurred. In the past, it wasn't that enforced as much. Now it's enforced. Number 3, this is the interesting one, the DPO. You appoint a DPO. A DPO in the past, right, for most organizations, especially the small, medium enterprises, just consists of a clerk who went for 1 or 2 courses. But the interesting part is there has not been clarification what constitutes a DPO. In Singapore, you must have 10 years experience with the particular qualifications. In Malaysia, I would argue for the threshold to be a bit lower to increase the barrier, to reduce the barrier of entry, and as well as to ensure those who have been practicing this field in the past, it was not a requirement to get any certification. It was mainly just clerks or people who know about data privacy to enforce data privacy principles. So in Malaysia, I would like to see the threshold being reduced, maybe let's say even to 1 or 2 years, because to be frank, we need more DPOs in Malaysia, as this is relatively a new requirement. Number 3 is data portability rights to remove your data and all that stuff and put it to a different, let's say you're using Maxis now, and instead of Digi, the Celcom company, you can take your data and transfer it across. Biometric data now is just sensitive data. So your fingerprints and all that are sensitive data, which comes under the PDPA. So it's being protected here. One moment. There are some rules changes to the cross-border transfer. In the past, we used to use a white list and a black list to prevent certain countries, data being transferred to certain countries. However, right, this power is being removed. It will be removed, and the transfers would be a different regime would be passed. And lastly, this is the new data. I mean, this is mostly, in my opinion, retention principle. You have to delete deceased person's data. So that means a person dies, you delete the data. So in a way, this is good because it prevents the unnecessary leaking of data, because the person is gone. So, and you don't want the data to be leaked. So you reduce the amount of data you are holding to ensure that the data doesn't get leaked. The data you hold does not get leaked. And I would like to conclude with this session. Sorry for being a bit quick because I was told I got 30 minutes, but I think I covered most of the grounds. Thank you very much.
Thank you very much, Mr. Rajit, for giving such an informative and comprehensive presentations about the Personal Data Protection Act in Malaysia for the first sessions. Ladies and gentlemen, a kindly reminder that if you have any questions, you can list on the chat features and you might write in Bahasa, and I will translate it to the addressed speaker, but it will be answered in the last sessions after the third speaker finish his material. Now we proceed to the second speaker, Miss Duan Yanran, aka Miss Dolores. Miss Dolores is, but she preferred to be called as Miss Dolores. Miss Dolores is originally come from China. For the bachelor degree, she was graduated from East China University of Political Science and Law, majoring International Economic Law. For the master degree, she was graduated from University of Hong Kong, majoring Master of Comparative Law. During her academic year, she also involved into some volunteer activities such as China's Cybersecurity Week and ISAC, International Volunteer Activity in Sri Lanka. She also passed the legal judicial examinations and got her lawyer's license of the People's Republic of China. Now we proudly present our second speakers, Ms. Dolores. For the next 30 minutes, time and Zoom are yours.
Okay, hi, please give me a second for share screen.
Sure.
Can you see this?
Yes, Miss.
Okay, let's start. Good morning, everyone. Sorry, I can't open my camera because it's broken. And I'm from China. You can call me Doris. It's my great honor to have the opportunity to share this research with you today. The topic that I want to discuss is legal regulation of the facial data utilization in China. In recent years, facial recognition technology, we will call it as FRT, has seen widespread application globally. Where its convenience and security are significant, it has also raised numerous legal and ethical issues. We will explore how to legally regulate the use of the facial data for 6 perspectives, as outlined in the agenda. First, let's take a look at the current state of the facial recognition technology. With the accumulation of the data advertisement in core technology, the threshold for facial recognition technology has gradually lowered. FRT utilizes artificial intelligence techniques like deep learning to extract and compare facial features, serving as a novel method for identify verification. This technology is efficient, accurate, and currently playing a very important role in various fields. FRT is not only important for safety, public safety, and smart city development, but has broad application prospects in the entertainment and permanent sector. For instance, in China, FRT is used in airport security. Security checks and boarding process significantly enhancing efficiency and security. China is the largest consumer market for FRT. However, these applications has also brought numerous issues and controversies. Additionally, the entertainment use FRT has lowered the threshold for collecting facial data. It's common to exchange privacy for convenience or entertainment. In many third-party payment and in-night finance sector, companies collect as much biometric information as possible from individuals using FRT and voice recognition technology. For For example, Baidu, I don't know whether you know this application is very popular in China. Use live facial recognition technology for account recovery, where WeBank and Alipay, I think you know this, Alipay use voice and FRT for account opening. On August 30, 2019, as we call it as Zao application, as issued in this peak with slogan that only one photo to experience the Chloe's trend was launched. Users could register it with a phone number and upload a front-facing photo to replace characters in videos or short clips with their own face. It's very interesting, to be honest. However, this application privacy policy didn't mention that the face swapping feature requires a collection of the facial data. If users refuse to provide facial data after registration, they could not use the core function. Furthermore, the authorization agreement was permanent, irrevocable, and transferable. This mandatory data collection clause not only seriously violates users' right to informed consent, but also allow personal sensitive facial data to be permanently and free used for commercial purpose. So do not download this application. It's not good. Okay, and from a legal perspective, the use of the facial data face several changes. Firstly, there is the issue of the privacy protection. Facial data is considered personal sensitive information and should be strictly protected. Facial data can accurately and unchangeably identify an individual, revealing race, skin color, health status, and even emotions. Thus, if large-scale facial data sets experience a security breach, it would open the door to fraud and counterfeiting. However, many companies do not fully consider users' right to informed consent when collecting and using data. For example, many mobile applications collect and users facial data without their explicit consent, violating privacy rights and potential breaching data protection laws. Chinese legislation model, administrative regulation, and judicial response lack substantial understanding of the rules governing facial data usage. Even specific measures may not solve the complex contradictions in facial data utilization. And second is there is the issue of the data misuse. Some companies excessively collect and illegally trade facial data for commercial interest, seriously infringing on users' privacy data. For instance, some companies share users' facial data with advertisers and third parties partners for significant profit, often without users' knowledge. Moreover, the widespread use of the FRT poses a significant security risk. Facial data is immutable, and once it's leaked, it can cause irreversible damage to personal privacy. For example, in 2018, I hope the year is right, a well-known social media platform experienced a data breach where the millions of the users' facial data were illegally obtained and used for commercial purpose. This is not only violate users' privacy rights, but could also lead to severe identity theft and fraud. For example, after Shenzhen Fengchao, I hope you know Shenzhen is a very big chain. It is a very big city in China. Technology company implemented the face scan for package retrieval feature in smart lockers. Elementary school students managed to deceive the system using photos. Besides Fengchao, logistics companies like Cainiao Network and Zhongtong Experience also introduced smart lockers with facial recognition features. Balancing public, thus we can see that balancing public safety and individual freedom has thus become a very important issue. Internationally, the United States and the European Union has rich experience in data protection. For instance, the European Union's General Data Protection Regulation, we call it as GDPR. GDPR has set strict standards for personal data protection, requiring data protection and processing obtain explicit use consent and ensure data transparency and accuracy. The GDPR applies not only within the EU, but also to the international companies, processing data of the EU resident, significantly influencing global data protection regulation. In United States, a decentralized regulatory model is adopted with the states in enacting different law and regulations based on their condition to vary restrict the use of the FRT. For example, in August 2019, Massachusetts passed the legislation prohibiting government and the policy use of the FRT and rules evidence obtained through FRT is inadmissible in the states of the court. And thus, China, we can learn from this successful experience and formulate data protection laws that face its national condition. And let me introduce the theory because it's very popular in China. In China, some scholars has proposed using responsible regulation theory to regulate facial data. Let's briefly look at the elements of the responsible regulation theory. Responsible regulation theory, first proposed by the Australian legal scholars John Braithwaite and Ian Irons, emphasize that the law and regulations should be flexible and adaptive, capable of adjusting based on social changes and technological advancement. Responsible regulation theory suggests that the regulation should not be addressed existing issues, but also be forward-looking to anticipate and prevent future risk. It advocates for multiple levels, multiple stakeholders approach to regulation using various regulatory tools and mechanisms to maximize society benefits. Key point emphasized in responsible regulation, including the flexibility. Laws and regulations should be flexible enough to adjust to changes social and technological environment. Stakeholders participation. Regulation should encourage the participation of the multi-stakeholders, including government, industry organizations, enterprise, and the public to form a collaborative government model. Gradual regulation. Regulation should adopt a gradual approach, escaping from the mild guidance and recommendations to strict legal and administrative measure based on the severity of the violations. So, by applying responsible regulation theory to legal regulation, we can construct a multi-dimension, multi-stakeholder legal framework for FRT, including the following aspects: industry self-regulation. Industry self-regulation is a very important way to achieve data security and legal use. By establishing industry standards and norms, encouraging self-regulation among enterprise can effectively reduce the risk of the data misuse and leakage. For example, industry association can formulate self-regulation agreement for the use of the FRT, requiring enterprise to adhere to strict privacy protection standards in the data collection and use. The IEE, a major standards setting body in electronic and information science, has developed over 1,300 standards, including many international standards for biometric information usage. Domestically, standards for biometric data usage are taking shape. The Internet Finance Authentication Alliance, we call it as IFAA, started by the China Academic of the Information and Communication Technology and company like Huawei. And I think you know this, the phone is very famous. In 2015, has grown to over 200 members, providing industry security solution for identity recognition technology and aiming to establish a trusted link and create a secure ecosystem. And the third one is about the special, oh, it should be second one, sorry. This should be the special legislation in enacting dedicating FRT laws can clearly define the boundary of the data collection and use. For example, the EU's GDPR, as we just talked now, provide a model for global data protection legislation. In China, we can also to establish similar laws that specify requirements for the collection, storage, use, and the distribution of the facial data to ensure the full protection of the user's data privacy. And third one is about the administrative supervision. Strengthening administrative supervision to severely penalize violation of the data protection regulations. Regulatory agencies should be regularly inspect enterprise data protection measures to ensure compliance with the legal requirement. For example, regulatory agency can ensure enterprise fulfill their data protection responsibility through regular audits, random checks, and users' compliance investigation. And finally, the judicial remedy, providing effective judicial remedy to protect personal data rights. Through this, individuals can legally define their rights and hold accountable those responsible for the data breach and misuse. The effectiveness of this can protect individuals' legal rights and serve as a deterrent and education tool, promoting enterprise to be more cautious in data protection. One notable case that highlights the importance regulatory of the measures is Clearview AI incident in the United States. Clearview AI, a facial recognition company, scrubbed billions of the image from social medias and other websites to build a vast facial recognition database without obtaining consent from individuals. This led to the significant public outcry and legal changes, promoting severe state of the consent sticker regulation and use of the FRT. This cause underscores the need for robust legal framework to prevent unauthorized data collection and protecting individual privacy. In addition to regulatory measures, public awareness and education play an important role in response use of the FRT. Educating the public about the potential risks and benefits of the FRT can empower individuals to make informed decisions about their data. Public companies and education programs can help raise awareness about the privacy and encourage responsible behavior among both consumers and companies. Furthermore, international cooperation is essential for addressing the cross-border implication of the FRT. As data flows across borders, regulatory measures in one country can have global ramification. International agreement and collaboration can help harmonize data protection standards and ensure the individual privacy rights are respectively globally. Organizations such as the International Association Privacy Profession, as we just called the IAPP, and the Global Privacy Assembly, the GPA, facilitate dialogue and cooperation among countries to address privacy and data protection. In conclusion, where the development of the authority is inevitable, we must find a balance between the technology application and the privacy protection. By applying responsible regulation theory, we can build a more significant and reasonable legal regulation. That's my hope, and I hope it's true. And that's all. Thank you for listening, and I hope it's helpful to understand China. Thank you again.
Thank you, Ms. Dolores. That was a very knowledgeable and engaging presentations about the responsive regulations of facial data usage in China. Ladies and gentlemen, after we know about the comprehensive outlook of data privacy in Malaysia and China, now it's time to have a local perspective with our last but not least speakers, Mr. Aryasta Wibisono Aditya. Mr. Aryasta is a lecturer in law program Unjaya. For his bachelor and master degree, he was graduated from Universitas Gadjah Mada, majoring law, and Master of Notarial Law in Universitas Indonesia. Mr. Aryasta has amount of achievement during his academic year, but right now I will only mention the most recent achievement of Mr. Aryasta. During 2024, Mr. Aryasta has become second best winner of legal blog writing at hukumonline.com and winner team of Hack Corruptions Malaysia. Right now, Mr. Aryasta is pursuing his doctoral degree in University of Malaya, specifically in cybersecurity in cryptocurrency. Now, without any further ado, for the next 30 minutes, Mr. Aryasta, time and Zoom are yours.
Check. Is my voice? Can you hear my voice, guys?
Yes, sir.
Okay. Okay, thank you very much. I would like to extend my gratitude to the committee and also to my colleague speakers, Ms. Dolores and Mr. Ajit. Thank you for shedding lights into personal data privacy protection. And we know that personal data is very, very much important to us to protect. So like Indonesia, for example, Malaysia and China is, I think, 10 steps ahead of Indonesia. But yeah, we are now learning to establish a better data protection law. And thank you also for the first and second speakers. Because of you, I don't need to talk more because the essentials were told by them, the essentials of personal data protection. So let us move on into. Wait. Let me introduce myself. My name is Aryasta Wibisono Aditya. You can call me anything, but I prefer you to call me Aries or AR to make everything simple. And then, yeah, this is very much interesting. We know your face in Zoom, and we can collect your facial recognition. We can collect your facial expression. We can record it, and even this webinar is live streamed to YouTube. Do you feel some kind of worriness about your data breach? For example, you register for an account, for example, Instagram, TikTok. Before you register or sign up to the application, you have to share your name, you have to share your birth date. Sometimes in your mind, have you ever thought that you I a little bit worried about my data. Have you gone like that? Have you felt like that? If you don't feel that you are need to worry about your data, then you have to learn more about personal data protection, because your information, even your voice, even your facial expression is money. Our money, I'm sorry, our money to someone, to some entities, or uh, any other parties, I don't know. But yeah, your voice, your biometrics, your fingerprint, your retina of your eyes, and then even your skin or hair or something that is special to characterize you, that could be your data, your information. Whether it's sensitive or not, we don't know yet, because we are about to delve to personal data protection in Indonesia. If we talked about other than Indonesia, like for example Malaysia and China, I pay attention to their data privacy protection law. They have the same similar things to Indonesia, but also they have also their distinctive characteristic aside from Indonesian counterparts. I will tell you later. For the China counterpart, Miss Dolores talked about facial recognition technology, FRT. Whether they we cannot avoid the emergence of technology. We have to use it, however, in our we have to use it in our life, and we cannot avoid it in the next future. We have to eventually we have to apply it on so many aspects of our life. Okay. I will cover 3 takeaways. The first is about introduction. I will make it short. And the second is the importance of personal data protection in Indonesia, of course. The third and the last one is personal data protection in Indonesia. The essential understanding how we can easily understand Indonesian personal data protection. Next, I will talk about, okay, looking at yours, Ms. Dolores and Mr. Anjit, your constitutional law, your regulatory tools on how your law is entry into force to the citizen. We have our own hierarchy of laws. And this is a little bit easy to understand if you only read the table. But if you are practically getting involved in lawmaking or enforcing the law, it will not be that easy. So if you talk about GDPR, before GDPR getting into our country, getting entry into force to our country, we need to make a sort of kind of procedure, the legal one. So we need to make a regulation. The regulation has to include something or say something about we are admitting that GDPR is important. So we pass this bill. And after this bill getting into force, everyone should comply. We have to make that kind of procedures before any other internationally agreed agreement entry into force to our country. So there's so much we have to learn in Indonesia, but I will make it simple. So this is the hierarchy of laws in Indonesia. But to understand about data privacy protection, personal data protection, we have to start within 6 laws, 6 regulations. The primary regulation, we can say also legislation for personal data protection in Indonesia is law number 27 of 2022 on personal data protection. I will describe shortly about the data protection law, personal data protection law. The personal data protection law of Indonesia is a little bit immature. Why? Because we need to take the transition steps. It is not yet established. And the Ministry of Communication and Information also preparing the best to at least what is it? Change from the first power of data security on them to the other entity named data protection officers, just like Mr. Ajit said before. In Indonesia, we are still currently establishing the concept of data protection officers. At first, the data protection officers hold the power holded by the ministry, but now the ministry has to taken it off and then appoint another data protection officers. And also about the data protection officers, in the regulation itself, in the PDP law, we still don't have the exact specification required. So we don't have the one like in the Singapore data protection privacy law. We still globally describe what is data protection officers and who are they without mentioning the specific requirements for them to be appointed as the data protection officers. And the other we have electronic information and transaction law. And between number 2 and number 1, both of them are our main or primary legislation that is talking about personal data protection. They are interconnectedly used in the data protection matters. And if you see in the screen, there are also 4 more of regulations, but we are not talking more about them. We are focusing on the first and the second regulations. And let's go to the next point. What is personal data? To make everyone understand easier, I draw this information from the regulation. So if you are, for example, you want to run a business in Indonesia, or no, you are just taking your leisure time to Indonesia traveling, and at some points you are collecting Indonesian data, or you are involved in data collection across Indonesia in the territory of Indonesian government, then those descriptions apply to you. Personal data means data relating to an identified or identifiable individual, wherein an identifiable individual is a person who can be identified either independently or in combination with other information, directly or indirectly, through an electronic or non-electronic system. The definition is indeed broad. But if you delve more into the regulation, into the law, you will see that they categorize the personal data into 2 categories. The first is general personal data. The second is special personal data. But I am agree with Mr. Ajit and also Mr. Dolores. We need to go further describing what are they actually, because if we talk about facial recognition in our law, it is categorized as special personal data. So biometrics is something that is inherent to our identity directly because it is biological. So for example, your fingerprint and your retina of your eye, and then your skin, your heartbeat, your hair, anything about you biologically, yeah, it is biometrics. So if you want to know what is personal data in Indonesia, you should read about the law. And there you can find that health data and information is distinct with other special personal data like biometrics, genetics, data on children, personal financial data, etc., etc. You can find it on the our personal data privacy protection law. It is easy if you are going to understand what is law in Indonesia, especially personal data protection. You can just go to the law itself and then you read the regulation, and there you can see that what is our main concern in personal data protection. Yeah. And then you can see that in Indonesia, we can say Indonesian legal system is ancient legal system because we still use penal measurement. So criminal law is our main concern sometimes if our regulations involving in public matters. So for personal data protection, we have a criminal punishment. We have penal punishment for you to impose to you if you are violating some of the articles. And then we are going to next. Yeah. As just mentioned by the first speaker, you have to know, everyone has to know about personal data controller and personal data processor. So we have two, and eventually we have the one more entity. The name is data protection officer, and the first two are personal data controller, or we can say it as controller, and the second one is personal data processor. As we know, a controller is an entity that establishes the objective and it has authority over handling personal data. In contrast, a processor is an entity that processes on behalf of the controller. So to simplify everything about in the screen, a processor is the entity appointed by the controller. So the processor is extended power by a controller to handle the personal data. The controller and the processor can be individuals or public agency, public bodies, or international organizations. And then I'm not talking about who are specifically who are the controllers, who are the processors, but we have to know that talking about data protection, there's someone who responsible for storing the information and how the information is used, how the law over the information is enacted and complied. That is the personal data controller. The personal data processor will be have the extension of power from data controller. So data processor is responsible for to the data controller. It has the same, at least the same power and the same responsibility as the data controller. But we are not talking more about that. We are talking about if you are involved in data collecting in Indonesia, you should read article number 20 to 54 in the law 27 of 2022 concerning personal data privacy protection. And then, yeah, there will be more explanations about who and how you protect your data. And then the most interesting of our data protection law is we have I don't know whether outside of Indonesia, I don't know whether the personal data protection law outside of Indonesia is mainly driven by civil law, meaning that every violation could lead to sue, and not like Indonesia. In Indonesia, if you are violating a particular articles, some of them imposing a criminal sanctions, meaning that you will be in jail or fine with that lot amount of money. And other than that, other than criminal sanctions, Indonesian personal data protection law also impose an administration sanction, meaning that the administrative punishment is only imposed to make everything or make the administration goes smoothly. It's not like the other one, the criminal sanction. If you are imposed by criminal sanctions, you will likely to suffer. We can say that criminal law is a law that makes everyone suffer. And yeah, they will take away your fortune. They will take away your freedom. But however, we need to add criminal sanctions to our personal data protection law because we need to be strict, at least to make you comply with the data protection law. Okay, let's go to other screen there. And then in this screen, I will talk shortly that the data protection officers now is being established, and just like other countries, Indonesia is trying to establish data protection center by moving from the Ministry of Communication Information to other entity named Data Protection Authority. And it is mentioned in the data protection law, and we have a transition period to do that. So we still have time to make everything, we still have time to accept the data protection law. And okay, supposedly in this page, we can see 3 others pictures, but unfortunately they are not shown. I think it's data data processing matters, but I don't know. Let's talk about the upper one, the middle one, who is shown. Back then in the old times, when you saw data breach, 1,000 is very much of cases. And now, when you see 100 million records data breach, you still like relaxed. Everything is under control because we now shifting the data protection. Yeah, unless we know more about data protection, we still can be shocked because we cannot know whether our data is leaked outside or not. But the thing the things are not in the picture, but these are. This is the challenges in Indonesia right now. We are facing the transitional period. We still need more time to adapt to the data privacy protection, data awareness, and we also have the unforeseen outcome. We don't know if it's not enforced now. It is enforced now, but we don't know how is the implementation in the field there outside, in the business or the individual out of business. I don't know. We don't know. We still don't know. We need to wait for further implementation, and then we have to taking steps. We have to take steps. During the period of transitions, we need doing more knowledge discussion like this, and we have to discuss more with other countries just like this webinar. And then okay, and that's it. Thank you for your attention, and now I will pass over to Miss Gina. Thank you.
Thank you, Mr. Aris, for such a great and insightful explanations on personal data protection law on data privacy in Indonesia. Privacy should be essential and should be a basic human right because it is not that we have something to hide. It is because we have something to protect. We lock the doors and shut the windows in our homes. It's not because we are doing a Walter White or hiding 15,000 tons of crystal in our basement. It is because we want to protect our valuable from being stolen or because we don't want to be stalked. Ladies and gentlemen, now we have come to the sessions of question and answers. I invite the audience to raise the virtual hand to ask the questions or list the questions in the chat features. Please.
Miss Gina, can I ask?
Yes, sir.
Because I am curious to Mr. Ajit and also Miss Dolores.
Sure.
The question is simple. Do you have criminal sanctions imposed to data privacy violation in your country, Mr. Ajit and Miss Dolores?
With regards to Malaysia, it would be as data privacy, I would say no, because if I went through the penal code, I don't think there's a criminal sanctions aside from a fine. However, right, I recall Vietnam does have it, but it's a decree. Once it's a decree, it's not an act of parliament, it's a decree. And also it's regards to data of children, because of the reason that in Vietnam, they are more focused on criminalizing data breaches or what do you call ending data related to kids is because of child trafficking and child pornography in Vietnam. So the decree is meant to tackle that issue in that aspect. But I mean, I agree with you, Park, because I feel that the CEOs and all the DPOs, everybody needs to consider data privacy at the forefront of the board meetings and all that. So to criminalize it would ensure that it gets discussed whether they like it or not. So as for now, based on penal code, no, I would say.
Okay. Because once when I applied for my PhD proposal to a university in Malaysia, the professor asked me, why you go into data protection and why you proposing that data protection is much more criminal law. They cannot accept it. They cannot accept it because they don't have the framework of criminal sanction into the data privacy. Data privacy is much more civil law. It's about individuals
Yes.
who gain damage, and we cannot go for a criminal law. So can you change? And then okay, let me change, and then from that time, I need to go to other things. I impose other crimes in my country that is also similar to yours. And
Yes.
okay, thank you very much, Mr. Ajit. And how about it, Miss Dolores?
Okay, as far as I know, we have the data protection into the British law, but I don't think it's very clear. That's the reason why I think that they need to modify it and need to change. But in China, if we want to change the law, it's very difficult. So I'm not so sure whether they can be better.
Okay, so in China, to put simply, they don't have, at least for now, the criminal sanction of the data privacy breach.
No, indeed they have, but it's
Okay.
not so clear. You
Oh,
need
oh.
to, yeah. You need to think and think and think. You can
I
use it.
I see. Okay. So just to make your information more, what is it, rich, in Indonesia, about data privacy, we also don't have that specific articles that is includes every crimes that is this and that. So we don't have specific conduct of wrongdoings that is categorized as criminal or crime in data privacy. We still need to go to other law, the Electronic Information and Transaction Law, to look for the crime. And for data privacy, for data protection, for data processing, we still don't impose much more on criminal sanction. So yeah, we still need to also amend our law on data privacy. Okay, thank you, Mr. Dolores, and I pass over to the moderator. Back.
Okay, thank you, Mr. Aris, for the questions. Now we have 4 questions, 2 questions in the chat features and 2 raised hand in the Zoom. But for the first questions, I will read 1 questions from the chat features. It's from Ulung Prastiwi. The questions seems to be addressed to Ms. Dolores. The question is there any reason why Chinese people prefer to use apps or similar things made by Chinese people themselves? Is this the way governments of China move to control Chinese people's data protections?
Okay, very interesting questions. Okay, the first, the government didn't control us to use the data, didn't have the move to control us. This is the first. And the second, the reason why we prefer to use the application made by Chinese people is because we think it's more convenience for us. For example, even though I said that the FRT is not good, but to be honestly, it's very convenient when you can use it. You don't need to take your phone if you use FRT. You just stand there and let it scan your face, and you can pay the money. It's very, very convenient for us. But as we know, data protection is also a problem. Anyway, the biggest reason why we use it is because it's more convenience for us. Thank you.
Okay, thank you, Ms. Dolores. And the next questions will be asked by Ms. Talia Christine.
Okay, thank you very much. Thank you very much, Mrs. Gina, for the chance. Before I ask question to Mr. Ariesta, I'd like to tell that I'm so sorry if my English is not that fluent, but I'll try to ask you. For Mr. Ariesta, the question is, in the context of global personal data protection, how can multinational organizations effectively balance compliance with various different regulations, such as GDPR, CCPA, LGPD, and PIPL, while maintaining operational efficiency and innovation. Maybe you can maybe you can answer the question with provide examples of specific strategies that maybe can be implemented. Thank you.
Okay, I will answer you right away. Just this night, I read so many articles about accepting data privacy protection law. It is hard. So to show you how it's hard, let me show you the picture that I supposed to show you all, guys. So that we can see in the screen when you try to access the data after they impose the data protection law, it is hard for them to expose. Even it's about you, it's about the personal data subject. So it is not easy because data is valued by money now. And then the next one below, the middle law, data protection, even it's secure, it is highly secure, a human error can breach everything. So we now see that human error is enough to make 100 million personal data leak on the on internet. And the last one, before the cybersecurity attacks, you thought you don't need money to improve your security, your data security. But after the cybersecurity attack, your money is much more in every part of your cybersecurity. In conclusion, I also want to share one more page to answer. Our data protection law started when the European Union started about GDPR, and that makes everyone in every countries in the world scared and also stressed. Why? I will show you how. I will show you why. Okay, let's scroll to the first page, and I will emphasize why. I will block it, and I will let you read, and I also read. The GDPR is the toughest privacy and security law in the world. Because of this, we need to protect our data. This is the birth of every chaos in data protection. So it is not easy. Even United States have to impose so many procedural safeguards to make their personal data privacy of their citizens secure. And also us. It is not easy. We talk about the law. We don't know about the technical things that the IT people know. So how to secure the layers, how to put the layers of security for our data privacy, we don't know. That is why we need the IT people here, because they are the only person know about protecting. But at least for now, we need to take awareness on data protection. This is the least we can do, is to discuss like this. What is data? Is your face is a data? Yes. Is your voice a data? Yes. Is your facial expression is that or data? Yes. Everything can be data, and also money. Because when we, okay, for example, before you going to this webinar, you need to register. You input your name, WhatsApp number, email, this and that. We can by what is it? By crime, we can do that to sell to someone, third party. But we don't want the criminal impose to us. And then we have to protect it. If someone leak the data or breach the personal data to some other entities, we need to investigate and we need to retract the data if it can be retracted. If it's not, then yeah, that is our weakness. We cannot withdraw the data that is already spread. And to answer shortly, we need to go for a discussion like this more, and then we need to make some other measurements and safeguards procedures to make our data protected and secure. Thank you.
That was a comprehensive answer, Mr. Arista. But Ms. Talia, do you have any follow-up questions after hearing from Mr. Ari's answer?
No, I think that's enough. Thank you very much for the answer, Mr. Arista.
Okay.
You're welcome.
For the next hands, there is Mr. or Miss Ashok. You can put on your microphone on.
Okay.
Okay.
Am I audible?
Sorry.
Am I audible?
Yes, you can.
Yeah, you can.
Before,
You're audible. We can
Yeah.
hear you. Yeah.
before mention the questions, please also mention the address speaker first. Thank you.
Okay. Thank you for the opportunities, and thank you to the speaker who give us a comprehensive explanation about the data privacy in your own area. And to begin my questions, I really interest. Could you provide an overview of the development of e-commerce in Malaysia and China? Because in Indonesia, the growth of e-commerce has been remarkably rapid, with the country being recognized as one of the largest and fastest growing e-commerce market. And this might be somewhat specific to the aspect of competition law, but in today's digital era, customer data has become an extremely valuable asset, especially in the e-commerce sector. E-commerce companies can collect and analyze customer data related to habits, preference, and interests, which is then used to enhance services and personalize shopping experiences. However, with the power that comes from access to this data, there are growing concern about the potential for unfair business competitions. Larger companies with more resources may be able to leverage this data more effectively, which could lead the market dominance or even monopolies. In Indonesia, although there are regulation or laws related to personal data protection, there is not yet regulation especially governing how e-commerce companies should manage the consumer data they collect, if I'm not mistaken. This presents its own challenge in balancing consumer protection with maintaining healthy competition in the sector. And then my question is, how do data privacy policies in your country allow e-commerce companies to access and analyze consumer data such as habits, preferences, and interests? And second, considering the potential impact of this access, do you see any risk of unfair business competition, especially when larger companies are able to leverage this data more effectively? And my last question, if so, what strategies or measures can be taken to mitigate the risk of monopolies or market dominance arising from the use of consumer data? Okay, thank you.
What a brilliant questions, Mr. Ashok. So the questions is addressed to Mr. Ajit and also Ms. Dolores. So I think Mr. Ajit can answer the questions first, please.
Yeah, okay. In the context of Malaysia, it's usually relegated to, in the past, it was relegated to privacy by design because the combination then doesn't have much power. So it's usually up to the businesses or complaints from the data subject for businesses to enforce their rights and all that stuff. However, with the recent, with this new minister or technology, I would anticipate some changes. Yes, e-commerce is growing exponentially. For example, Shopee and all that stuff. Shopee, e-wallets, Touch and Go wallets is growing. But I mean, now there would be changes, but it would be very early to see what would happen. I know the minister has a lot of plans, but it would be nice to just see what's going on now at the situation, because now the focus is on the data privacy bill, the amendments, the few amendments I spoke about. So it will be an interesting development that you need to wait. I would say you need to wait and observe what is going on and what plans both businesses and Malaysia and the government imposes. But as for now, I would say it's mostly relegated to privacy by design and businesses taking care of people's data at this stage by themselves. Thank you.
Okay, thank you, Mr. Ajit, for answer the questions from Mr. Ashak. So is there any Miss Dolores in this room?
Yeah, I'm still
Okay.
here.
Okay, please answer the questions from Mr. Ashak.
Okay, thank you your questions. And I think the question, the key part is about the industry self-regulation. And if we want to talk about the industry self-regulation, we need to go back to China and we see the organizations. For example, if you want to know this part, you could find the organizations, we call it as IEE. In China, it's the major standard setting bodies in electronic and information service, and it has many standards. For example, it has, as far as I know, maybe it's 1,300 standards, and it includes the international standards for biometric information. You can search for your questions is about the FAA, and it's the rule from the companies in China. So I think the IFAA, when you look at that, you will understand the China's self-regulation, how China's self-regulation works and how it regulates the FRA, the facial recognition technology. Thank you.
Thank you, Ms. Dolores, for perfect answer from questions of Mr. Ashak. So we have another questions in the chat features. I will read it to you. Hello, Miss Dolores and Mr. Ajit. Thank you for the insightful presentations. It's the questions from Johannes Chrysostomos Moda. So the first questions is, could you please tell me how do Malaysia and China's approach to data privacy differs in terms of regulatory enforcement and penalties for data breach? I think this questions has been asked by Mr. Ariasta in the first place, but if Ms. Dolores and Mr. Ajit want to re-explain to the audience, it's okay. And for the second questions is, with the increasing digitalizations of services around the world, including Malaysia, China, and also Indonesia, what the measures have been taken from the government of China, Malaysia, to handle potential conflicts about the privacy of the citizen? Maybe Ms. Dolores can answer the first questions and also the second questions, please.
Okay, I'm here again. Okay, that's a good question. But if we need to go back to China, we have to know one thing, that in China, if you want to change the law, it's very difficult. That's the reason that we do not talk about law, because we can change that. But to fix that, we still go back to the self-regulation. That's the reason why I always emphasize that, because we can change the law, but we can change the company rules. And let's go back to Huawei because it's very important in China. And I know maybe you use that phone; it's very useful. And still the FAA, and it's about the, I think it's about the 2015. The FAA has grown to over 2,000 members, providing the industry security solutions for identify recognition technologies and aiming to establish a trusted link and create a secure ecosystem. That's our main movement to, just fix because we can change the law oftenly. That's my questions. Still go back to the self-regulation. So if you want to research the China, there is my suggestion that you need to go back to the company, not the law, not the government. It's very important. Thank you.
Thank you, Ms.
Interesting.
Dolores.
Interesting.
Very interesting. So for the next, we have Mr. Ajit Sidhu to answer the questions.
Okay, with regards to Malaysia, in the past, there was not much, I would say, punishments or enforcement. Mostly businesses would get punished. And even then, right, the commissioner wasn't sure about the calculation to be used. For example, is it per data breach or is it by the data subject, the amount of data subjects information that was leaked or breached? So the calculation was not clear. As for now, I would say a stricter approach is being used, one that would ensure that businesses and the people in top management would comply at this stage. So, I mean, now with the amendments, it would be interesting to see what is said, but I agree with Park Arias, what he has said, to ensure maybe criminal punishment or criminal sanctions to ensure that businesses do take it seriously. But however, the issue with that is companies would want to try to mitigate this by either creating a scapegoat or either they would come up with a lot of defenses, for example, saying the CEO does not know about it, all that stuff. So that would be a point to consider before implementing criminal sanctions, but it's a good thing to explore, I would say. Thank you.
Thank you, Mr. Ajit. Is there any questions from the audience, or maybe the audience that want to just share or discuss with the speakers today? It not has to be questions. We are also open to discuss with all of the speaker here, Mr. Arista, Mr. Ajit, and also Mr. Lawrence.
I have to express something to our speakers and our participants. Personal data privacy protection is very, very important. Whether it's only in the first stage in Indonesia, it is immature in Indonesia, but in any other countries, we don't know what is the stage. But this is for everyone in here. If you want to take research on data privacy, it is good now because data privacy is a interesting topic for you to research, and it can be correlated or it can be intercrossed with other specification of law. For example, criminal law, for example, civil law, constitutional law, any others, you can name it. And for this kind of law protection, data protection law, we can also elaborate with others, like, for example, the security, cybersecurity, and also cryptocurrency and its legality in your country. And for now, it means China, Indonesia, Malaysia, or if you are coming from other country, you can also impose comparative law research. For example, Malaysia and Indonesia on implementation of cryptocurrency, this and that. And I would like to appreciate much to our speakers because willing to share about their countries and hopefully we can also talk more about data privacy in elaborate ways. Thank you very much.
Thank you, Mr. Ariesta. Apparently, we don't have any other questions, ladies and gentlemen. So we have finally come to the end sessions of this international webinar on data privacy in the digital age. Before I close these sessions, to Mr. Ajit, Ms. Dolores, and also Mr. Aris, are there any final thoughts before we end today's sessions?
Mr. Ajit and Ms. Dolores, you can deliver your thoughts to.
I mean, this is an interesting discussion we had today, but I think now we would need to see further developments from our respective countries, see what the plans and all that stuff. So I mean, now it's a bit early. Data privacy was it's relatively a new area, new and emerging area, like what 20 years back. So it's relatively new and it's quite interesting to see what happens in the future. Anyway, thank you for having me today.
Okay, what about Ms. Dolores? Any final thoughts?
Okay, it's my great honor to share the topic with you guys today, and I hope that it helps you to understand China because I know China is very complicated and very difficult to understand. Anyway, and if you are interested, I will share the presentation with you. And thank you. Thank you so much.
Okay, last but not least, please, Mr. Aris, deliver your final thoughts. Okay.
Thank you, Ms. Gina. Thank you to all of the participants and the committee. Thank you for talking with my super distinguished colleague here, Mr. Ajit and Mr. Dolores. I will look forward to discussing more about data privacy with you all, including with the speakers and potential researchers here. And that's it. Thank you very much for having me, and thank you for being super awesome participants and also speakers here today. Thank you.
Thank you for all of the speakers for the concise closing remarks. Please allow me to also take some highlight points from today's sessions. So today, the practice of that data mining to data theft is increasingly thrive along with the development of digital devices. Various sectors are vulnerable to becoming nodes for data leaks, including the collections of population data, telecommunications data, consumer data, and also financial data in the banking industry, social media, and so on. Such data leak can cause harm to data subjects in the form of economic losses to safety threats. As digital data retrieval and processing is becoming more widespread, there is an increasing urgency to finalize comprehensive personal data protections regulations. With a clear legal basis, personal data protection will have a stronger guarantee. Having such regulations is also important for the sustainability of the digital economy. And finally, ladies and gentlemen, I would like to thank the speakers, Mr. Ajit, Ms. Dolores, and Mr. Aris, for their informative and interesting presentations on data privacy in China, Malaysia, and Indonesia, and also to all the participants for their active participations. So see you all later on, and thank you very much. Over to Master of Ceremony, Ms. Talia.
Okay, we extend our gratitude to our speakers, especially Mr. Ajit, Mrs. Dolores, and Mr. Ariesta for the highly informative presentation. And special thanks to Mrs. Gina for excellently moderating this webinar. We hope you find the information and insights shared by our expert panelists to be valuable.
Can I request before
Remember?
we leave? Can I request before we leave this room, we can take picture together, even though some of us cannot be seen, but let us cherish the moment while we are together by turning on your camera and taking the group photos.
Yeah, sure.
Everyone, please pose yourself to your cam, and hopefully we can see others. We will wait for others to show yourself, make known to us. We will wait for about 2 minutes, and then we will afterwards we will take the screenshot. Okay, I will offer to the screenshot officer led by Mr. Wahyu, who are now taking
Yes.
seat. You can just counting down, Mr. Wahyu, and the others will take, including me. I will take it. Okay, it's enough now. Please take on your pose and we will count it. 3, 2, don't forget to smile. 1. Okay, the second layer of page.
Yes, next slide.
Okay. 3, 2, 1. Okay, the
then-
last one. 3 and 2 and smile. Thank you. I will offer to the MC. Thank you very much.
Okay, thank you so much, Mr. Ariesta, for guide us to take some photos. We hope that this webinar has provided you with useful information and strategies that you can implement in your own work. Remember, if you have any additional questions or want to learn more about the topics we discussed today, please feel free to reach out to our team. And we also would like to thank the audience for their participation and interest in safeguarding data privacy in the digital era. We believe that the information presented here will be beneficial to all who attend, and we hope that this webinar will inspire you to take action towards your goals. We also would like to remind you to fill out the attendance list through the provided G-form link. This step is crucial to ensure that you receive your webinar certificate, which will be sent to the email address you provide. Please take a moment to complete the form if you haven't done so already. We greatly appreciate your participation, and we want to ensure that you receive recognition for attending this important event. Thank you so much for your attention to this matter and for joining us today. We appreciate your time and hope to see you again soon.
Thank you everyone.
Thanks, Mr. Aris.
I heard someone saying my name.
Okay, guys. So I wanna give you some information. So there will be a door prize, and the committee will announce it in the group, in the WhatsApp group. Okay, thank you.
Hello, can we leave or do we stay?
Yes, you can leave. Miss Gina?
Mr. Aris.
Okay. Yes, you can leave, Mr. Ajit and Miss Dolores.
Thank you for having us here. Have a nice day.
Have a nice day
Have a
too.
nice
Thank you very
day.
much.
Thank you.
Assalamualaikum warahmatullahi wabarakatuh. Universitas Jenderal Ahmad Yani Yogyakarta merupakan lembaga pendidikan yang diselenggarakan oleh Yayasan Kartika Eka Paksi di bawah binaan TNI Angkatan Darat dengan visi menjadi universitas yang unggul dan terdepan di tingkat nasional serta mewarisi nilai-nilai kejuangan Jenderal Ahmad Yani. Universitas Jenderal Ahmad Yani Yogyakarta atau dikenal pula sebagai Unjaya memiliki sasanti Aditya Mahatma Daksa yang bermakna senantiasa menghasilkan lulusan yang pandai, bijaksana, berjiwa besar, cakap dan ahli, serta Unjaya berkomitmen mempersiapkan para Ahmad Yani muda yang nasionalis, patriotik, dan heroik.
Fakultas Teknik dan Teknologi Informasi Universitas Jenderal Ahmad Yani Yogyakarta saat ini mengelola 4 program studi, yaitu Prodi Sistem Informasi S1, Prodi Informatika S1, Prodi Teknologi Informasi S1, dan Prodi Teknik Industri S1.
Fakultas Kesehatan Universitas Jenderal Ahmad Yani Yogyakarta saat ini mengelola 8 program studi, yakni Prodi Pendidikan Profesional, Prodi Keperawatan S1, Prodi Kebidanan S1, Prodi Kebidanan D3, Prodi Pendidikan Profesi Bidan, Prodi Farmasi S1, Prodi Rekam Medis dan Informasi Kesehatan D3, serta Prodi Teknologi Bank Darah D3.
Fakultas Ekonomi dan Sosial Universitas Jenderal Ahmad Yani Yogyakarta saat ini mengelola 4 program studi, yakni Prodi Manajemen S1, Prodi Akuntansi S1, Prodi Hukum S1, dan Prodi Psikologi S1, yang kesemuanya diarahkan untuk menjawab tuntutan perkembangan ilmu dan teknologi di era ekonomi digital.
Sebuah kebanggaan bagi kami dapat mendidik dan mempersiapkan para Ahmad Yani muda sebagai generasi penerus kejayaan bangsa Indonesia.